A signed contract does not make you the owner of Texas real estate. A final walkthrough does not make you the owner. Even a closing statement does not make you the owner. What makes you the owner is the deed. And in Texas, there are rules about what makes a deed valid and what guarantees it and what even happens if something goes wrong. I'm Hamilton Rucker, a Texas real estate attorney, and today I'm breaking down everything you need to know about Texas property deeds, from what they are to the types you can encounter to how to correct mistakes and spot fraud. Texas Deeds, a comprehensive guide to conveyance and law. In this video, we're covering the complete picture of Texas deed law, from the foundational concepts that determine what makes a deed valid to the specific types you'll encounter in a real estate transaction, to recording requirements, community property rules, and the transfer on death deed. Whether you're buying your first home, selling investment property, or handling an estate matter, understanding how deeds work in Texas is essential to protecting your ownership rights. The basics: contracts versus deeds. Let's start with the fundamental distinction that confuses many buyers and sellers: the difference between a contract and a deed. Think of the real estate transaction like a relay race. The purchase contract is the first leg. It establishes the terms, the price, the timeline, the obligations. It is a binding agreement between the buyer and seller. But the contract does not transfer ownership. Ownership transfers when the deed is delivered. The deed is the baton handoff. Until that deed is signed by the seller, delivered to the buyer, and accepted, you do not officially own the property. This is why deed language, deed execution, and deed delivery are all legally significant steps that must be completed properly before the transfer of the deed is delivered. The ingredients of a valid Texas deed. Texas law does not require any specific magic language to create a valid deed. There is no standard form that's mandated by statute, and what Texas courts require are 4 essential elements. First, an identified grantor, the person transferring the property, and an identified grantee, the person receiving it. Both parties must clearly be identified. Second, the grantor's intention to convey the property. The deed must express the intent to transfer ownership, not just an agreement to transfer in the future. Third, an adequate property description, enough detail to identify the specific property being conveyed. Fourth, the grantor's signature. Texas courts have used a 6-part framework from ConocoPhillips versus Hahn. This case analyzed the deed's validity: the grantor, the grantee, intent, description, consideration, all of these things. If any of these elements is missing or fatally defective, the deed may be void or voidable. The handoff, execution, and delivery. A deed must be both executed and delivered to be effective. Execution means the grantor signs the deed in front of a notary. Notarization is required for recording in Texas, though technically a deed can be valid between the parties without it. Delivery is more nuanced. The grantor must physically or constructively deliver the deed to the grantee with the present intent that the deed takes effect immediately. A deed sitting in a grantor's desk drawer, given to an attorney to hold on to until I die, or handed to a grantee with the condition not yet met, may not constitute a valid delivery. It's the drawer rule, and it really provides that a deed placed in a safe or drawer held for later delivery does not convey title until actually delivered with intent. Once delivered, acceptance by the grantee is required, though courts generally presume acceptance if the conveyance is beneficial to the grantee. So Texas also recognizes another doctrine called the after acquired title. If a grantor conveys property they don't yet own and then later acquires that title, the title automatically flows to the grantee under estoppel by deed. The gold standard, general warranty deeds. Now, let's walk through the most important deed types in Texas. The general warranty is the gold standard. When a seller conveys by general warranty deed, they are making a full title guarantee to the buyer. I warrant that the title is good, going back to the very beginning. And if anyone ever challenges your ownership for any reason, going back to any prior owner, I will defend your title and compensate you if you lose. So this is the strongest protection a buyer can receive. General warranty deeds are standard in Texas residential real estate transactions. If you're looking to buy a home, this is what you should expect to receive. The seller's warranty survives the closing and can be enforced if a title defect surfaces years later. Limited protection, special warranty deeds. Now, the special warranty deed offers a more limited guarantee. The seller warrants only against title defects that arose during their own period of ownership. They are not warranting anything that happened before they own the property. This distinction matters a great deal. If there was a little defect created before the seller acquired the property, a forged deed in the chain, undisclosed heir, a prior lien, the special warranty deed does not protect you from it. Special warranty deeds are common in commercial real estate transactions and in bank-owned REO sales, in foreclosure deeds, and situations where the seller, like a corporation selling multiple properties, cannot reasonably warrant the full history chain of the title. It's just if they're in the business of real estate and they really don't know the details of all these other transactions that have occurred, that's when they're going to issue a special warranty deed. When you receive that special warranty deed, you should invest in a comprehensive title insurance policy to make sure it covers all the gaps. Proceed with caution. Quitclaims and deeds without warranty. The quitclaim deed and the deed without warranty occupy the bottom rung of title protection. A quitclaim deed conveys whatever interest the grantor has. Nothing more, nothing less. If the grantor has no interest, the grantee receives nothing. There is no warranty at all. A deed without a warranty similarly passes title without any guarantees of the quality. These deeds are not used in standard arm's length transactions in Texas. No informed buyer would accept one. However, they serve legitimate purposes, transferring property between family members where title is not in dispute, or clearing a claimed interest from a stranger to title, adding or removing a spouse from a deed because of a divorce, or correcting a technical defect. In those internal, family, or legal housekeeping contexts, a quitclaim deed without a warranty is the right tool to use. The risk is knowing when you're in a context where that's appropriate and when you're not. And that's where a real estate attorney can help you understand, should you even use this type of deed? Making it public, recording the deed. Recording a deed is not required for the deed to be valid between the grantor and the grantee, but failing to put that record out there is a serious risk. Texas is a notice state, which means that a subsequent buyer or lender who takes the property without notice of your prior unrecorded deed can defeat your claims. Here's a nightmare scenario for you. All right, you buy a property, you receive a properly executed deed, but you don't record it promptly. The seller improperly or fraudulently conveys the same property to a second buyer who records their deed first and has no actual knowledge of your prior purchase. Under Texas notice recording statute, that second bona fide purchaser may take priority over your earlier deed. The solution is simple. Record your deed with the county clerk immediately at closing. So title companies do this routinely as part of the closing process, but you need to verify that it happened. Your deed is your public notice to the world that you own this property. Precision matters. Describing the property. The property description in a Texas deed is critical. It defines exactly what is being conveyed. Texas uses two primary description systems. Lot and block descriptions are common in urban and suburban subdivisions. The deed identifies a specific lot number within a recorded plat, which is a survey map filed with the county. This is typically the simplest and cleanest description. Meets and bounds descriptions define property by its boundary lines, angles, and distances, starting at a specific point and tracing the perimeter. These are more common in rural Texas and older properties. So one important doctrine in Texas is the stripes and gores rule. If you own land on both sides of a narrow strip of land, like an abandoned road or an alley easement, a conveyance of your land generally passes the adjacent strip to the grantee unless explicitly excluded. Critical warning here: never use the appraisal district's property description in a deed. Let me repeat that. Never use the appraisal district's property description in a deed. Appraisal district descriptions are for tax assessment purposes, not legal conveyance. They're often imprecise and can create title problems. Marriage and ownership, community property. Texas is a community property state, and marriage directly affects how property is characterized and how it must be conveyed. The inception of title doctrine governs property and determines how it's classified as either separate or community based on how and when it was originally acquired. Property acquired during marriage using community funds is community property, owned equally by both spouses, regardless of whose name is on the deed. This has critical implications for real estate transactions. If a married person purports to sell community property without the spouse's signature or joinder on the deed, the transaction may be voidable by the non-signing spouse. Texas deeds should accurately state the grantor's marital status: a married person, a single person, a widow, and so on. And when community property is involved, both spouses must generally sign to convey clear title. Failing to address marital status correctly creates cloud on title that can take years and significant legal expense to clear. Avoiding probate, transfer on death deeds. One of the most useful estate planning tools available to Texas property owners is a transfer on death deed, often called a TOD. A transfer on death deed allows a property owner to designate a beneficiary who will automatically receive the property upon the owner's death. Without the property having to go through probate, here's how it works. The owner executes and records the TOD while alive. It has no effect on their ownership during their lifetime. They can sell the property, refinance it, or even revoke the TOD at any time. When the owner dies, the property transfers automatically to the beneficiary simply by recording a certified copy of the death certificate. No probate court, no executor, no waiting. The TOD is a powerful, low-cost alternative to holding property in a trust purely for probate avoidance purposes. It is not appropriate for every situation. For example, if you have creditor concerns or complex family circumstances, but for straightforward property succession, it's an excellent tool. When mistakes happen, corrections and fraud. Mistakes happen in deed drafting. Texas law provides a structured process for correcting them. Non-material errors, typos in names, minor formatting issues, technical Scrivener errors that don't affect the substance of the conveyance can all be corrected through a correction instrument under Texas Property Code 5.026. This is a streamlined process. Material errors like wrong legal description, wrong grantee, incorrect interest conveyed, those require a new deed executed by all the original parties under Section 5.029. The statute of limitations on deed challenges is generally 4 years, but the discovery rule can extend it when a defect is not reasonably discovered. Now, fraud. Texas deed fraud is a real thing and is growing. Warning signs include deeds with forged signatures, deeds that suddenly appear transferring property to unfamiliar entity, and deeds executed under suspicious circumstances around a death. Recording a deed does not make it valid. A forged deed is void. It's not just voidable. But removing a forged deed from the chain of title requires legal action, time, and expense. Texas has criminal statutes targeting deed fraud, and the legislature has strengthened them in recent years. Your keys to property ownership. Let me close with a couple keys to protecting your Texas property ownership. Always get a general warranty deed in a standard purchase. Understand the difference between what a contract promises and what a deed delivers. Ownership transfers when the deed is delivered and accepted. Record your deed immediately. An unrecorded deed is an invisible deed, and invisible deeds create invisible risk. Make sure your property description is legally accurate, not just a tax ID number. Address community property correctly. Both spouses convey in most cases. Consider a transfer on death deed as a simple probate avoidance strategy for Texas real property. And when something goes wrong, an error, a dispute, a suspicious conveyance, act quickly. The statute of limitations and the discovery rule both work in your favor if you move fast and against you if you delay. Texas deeds are the foundation of property ownership, and getting them right matters every time. If you have a question about a deed, you received a title issue on a property you're buying, or an estate matter involving Texas real estate, give me a call. The link is in the description below. And if this video helps you understand Texas deed law, please subscribe, like, and follow. We cover Texas real estate law topics every week. I'm Hamilton Rucker. Know your deed, know your rights, own your property.